We are a country of laws, and our oath that we swear is to support the Constitution of the United States and the laws of our country. And so as we engage in this process, what is important is the meaning of the Constitution, the facts before us, and that interpretation. And there can be no other consideration.
Hey again, everyone. It is 5 o'clock in New York. I'm Alicia Menendez in for Nicole Wallace. When Maine's Secretary of State made the decision last week that Trump's role in the January 6th disqualified him from running for office again, she was very clear. This was about what the Constitution said. This was a matter of facts and of the law. In just the last few minutes, Trump appealed that decision to the state Superior Court, saying that, quote, the secretary's ruling was the product of a process infected by bias and pervasive lack of due process, is arbitrary, capricious, and characterized by abuse of discretion. Critics of the secretary's decision, as well as the ruling by Colorado's state Supreme Court, which came to the same conclusion 9 days earlier, say that it should be up to the voters to decide if Trump is worthy of a second term in office. But to that point, former constitutional law professor Congressman Jamie Raskin says that the rulings in Maine and in Colorado are not undemocratic at all. In fact, quite the opposite.
We have a number of disqualifications in the Constitution for serving as president. For example, age. I mean, you know, I've got a colleague who's a great young politician, Maxwell Frost. He's 26. He can't run for president. Now, would we say that that's undemocratic? Well, that's the rules of the Constitution. If you don't like the rules of the Constitution, change the Constitution. If you think about it, of all the forms of disqualification we have, the one that disqualifies people for engaging in insurrection is the most democratic, because it's the one where people choose themselves to be disqualified. In terms of your age or where you were born, that's not up to you. But you know, Donald Trump is in that tiny, tiny number of people who've essentially disqualified themselves.
As different states have interpreted Section 3 and Trump's actions in different ways, we've seen a patchwork build across the country with different rulings, putting more and more pressure on the Supreme Court to ultimately decide Trump's eligibility. Meanwhile, in the ongoing quest to interpret Section 3, ABC News has taken a look into what the authors of the amendment truly meant by looking at their own words. They viewed transcripts of the Senate floor debate in 1866 when Section 3 was being passed. The clause was originally written after the Civil War to bar those from the Confederacy from voting. Senator Jacob Howard of Michigan wanted to expand it and stop former Confederates from serving in government altogether. And Senator Peter Van Winkle of West Virginia argued that this should look beyond the Civil War. Quote, this is to go into our Constitution and to stand to govern future insurrection as well as the present. And I should like to have that point definitely understood. So now, in this new year, in this presidential year, where the stakes for our democracy are at a critical inflection point, we wait to hear what the Supreme Court of the United States will decide. And that is where we start this hour with former U.S. attorney, author of the forthcoming book, Attack from Within, How Disinformation is Sabotaging America, and co-host of the #SistersInLaw podcast, Barbara McQuade. Plus, Princeton University professor and distinguished political scholar, Eddie Glaude, and senior opinion columnist for the Boston Globe, and another co-host of the #SistersInLaw podcast, Kimberly Atkins Storr. Barbara, before we dive into these big things, I want to talk timing. Last week, we saw an appeal by the Colorado Republican Party, which put into effect the stay that the state Supreme Court had laid out. Trump just appealed the Maine ruling a few minutes ago. Talk about what happens next and what are those next deadlines that we're watching out for?
Well, the Supreme Court is going to have to review this petition and decide whether they want to take the case up. They could decline to take it up and say, states, you're on your own. I think that is highly unlikely. Instead, I think they will take it up, and I think they have to take it up quickly. We're going to see the Iowa caucuses as soon as January 15th. Now, one of the things that they can do is to issue an administrative stay to sort of preserve the status quo and allow Trump to stay on these ballots until they sort it out. But I think time is of the essence here, and I think they need to decide it at least within the next month or so.
Well, to your point about time being of the essence, in just the last hour, Colorado's Secretary of State responded to the Republican Party's appeal, saying she too believes the court should act quickly. And here's what she wrote. As the above calendar demonstrates, expedited resolution of this case will ensure that Colorado voters cast ballots in the presidential primary election knowing whether Trump is qualified to serve as president. Providing this certainty is important both for the candidates in Colorado's Republican primary and, most importantly, for the millions of Republican and unaffiliated voters in Colorado who will be casting ballots in that election. The urgency, it is palpable, Barb.
Yeah, I think that's right. And, you know, she makes the argument in Colorado where I think they're a Super Tuesday state. And so she has said her deadline, absolute drop dead is something like February 12th. But in the Iowa caucuses, they're going to, go cast their votes on January 15th. And people could be disinclined to vote for Donald Trump. I mean, in Donald Trump's defense, if they think he might not be a viable candidate. And so to protect his interests, the court really needs to decide this very quickly.
Right. I mean, Kim, here's the thing. There are the legal arguments that are going to be made in court, and then there is also the discourse that is happening in the court of public opinion. I want you to speak to the point that Congressman Raskin made, that Section 3 of the 14th Amendment addresses the only type of disqualification where the individual actually has control, rather than seeing this as undemocratic, seeing it as particularly democratic.
Yeah, I mean, he's absolutely right that the Constitution contains a lot of limitations on who can hold office, including the presidency, the age being the one that we think of that's easiest. People don't quibble with that. But there are also all kinds of procedures about a primary election. And that's why I think that the challenges that are happening right now may not end in quite the bang as whatever comes with respect to the general election. In every state, you have different procedures by which candidates are chosen to be on the primary ticket. Sometimes it's through elections, sometimes it's through the choice of the parties, sometimes it's through a manner that's done by election officials. It's different in every state. So I think the likelihood that the Supreme Court comes in and makes a definitive ruling about the 14th Amendment at the primary stage, just given all of the procedural hurdles that they would have to jump over first, and the fact that, as Barb said, time is a ticking, that the primaries start this month, that's going to be really unlikely. And it gives the Supreme Court an out to say, look, sometimes if it's up to a political party to choose their candidates, we can stay out of it. But when it comes to the general election, they really can't. And I do think that we're going to get a decision by the summer with respect to this. But thinking that that's going to happen in the next couple of weeks, I think is really unlikely.
Eddie, to Kim's point, time, it is a ticking. And as much as we are looking forward, I do like this exercise of looking back and trying to understand the intent of the 14th Amendment. Again, ABC, they looked at the Senate debate that went on when it was being considered following the Civil War. ABC writing, this was my favorite part, but originalists might take note of what Senator Peter Van Winkle of West Virginia said as he sought to have the threshold for congressional amnesty in Howard's version lowered to a simple majority rather than 2/3. And there was this line we just read at the top where Van Winkle said, "This is to go into our Constitution and to stand to govern future insurrection as well as the present." And I should like to have that point definitely understood. Talk about the significance of the amnesty, as well as the senators at the time having what I would argue was the clairvoyance to look ahead, to think ahead to future insurrections.
I think it's really important. It's a really important piece to give us some historical context. You know, there's the piece of legislation that was passed, or the amendment that was passed in the House, and then what the Senate did. And I think it's important, Alicia, to contextualize it within the context of the ongoing violence of the Civil War. Of course, the 14th Amendment is ratified in 1868, but there's still, in very significant ways, rebellion happening in the South among those Confederates or former Confederates, however we want to describe them. And so for the senator to look forward is to understand that there are those forces that may, in fact, turn their backs, betray their oaths, and that would be disqualifying. And it seems to me that goes beyond just simply those participants in the Civil War. It goes to those folks who ought to live up to the oath of their office. But I want to say this. Our failure to hold folk accountable, our failure to hold the Confederates or former Confederates accountable actually had tangible material consequences. It had tangible material consequences in how the South was governed. It had tangible material consequences for the lives of those former slaves. So it matters. It's so ironic that the 14th Amendment, in all of its complexity, has been such a contentious issue since it was ratified. And here we are in 2024 still grappling with it.